Every major regulation carries its own syntax. When governments write privacy laws, the legal text directly dictates the functional requirements of your software architecture. If your engineering and product teams do not speak this specific language, they will design systems that expose your enterprise to massive liability. In India, that governing framework is now the Digital Personal Data Protection Act, 2023. It dictates exactly how user information must flow through your servers. Mastering these 20 terms is the starting point for building a compliant product in the Indian market. Start at the absolute foundation. Under the Act, personal data is any piece of information that can identify an individual. The core framework makes no distinction between sensitive and non-sensitive data. If it points back to a human being, it is regulated. Look at what your application collects at signup: an IP address, a mobile number linked to UPI, or the details printed on a PAN card. These are direct identifiers. The individual tied to that data is defined as the data principal. In commercial terms, this is your user, your customer, or your account holder. When that user is under 18, the law assigns all their rights and obligations directly to a parent or guardian. If you operate an edtech platform like Byju's or a gaming app, your registration flow must structurally accommodate this proxy rule. The data principal is an active participant in your database. The law grants them the right to access, correct, and erase their information. Your development team must build the actual interface tools to execute those requests. The entity deciding exactly why data is collected and how it is used is the Data Fiduciary. This is your startup. By determining the purpose, you hold the primary legal obligation, directly responsible for valid consent, cryptographic security, and reporting any breach. Consider a food delivery transaction. Zomato collects customer location data, dispatches the order, and later uses that data for targeted marketing. Because they dictate this process, Zomato is the fiduciary. The legal term fiduciary establishes a formal position of trust. If your system design fractures that trust, the liability falls squarely on your enterprise. Not every company touching data decides how it gets used. A data processor executes operations strictly on behalf of the fiduciary, following explicit instructions. Look at your infrastructure: the cloud provider hosting servers, the API gateway pushing OTPs, the third-party analytics running. These are all processors. You can outsource the computational work, but you cannot outsource the legal exposure. If your vendor leaks user records, the government holds you responsible. This dynamic demands strict data processing agreements. You must establish legal boundaries that explicitly block vendors from absorbing your user data to train their own models. Operating a modern tech stack without signed, mapped data processing agreements for every single API integration leaves your business completely exposed. To give users centralized control, the law introduces the Consent Manager. This is a registered, interoperable dashboard where individuals can view every organization holding their data and revoke permissions instantly. For a tech business, this requires immediate architectural changes. Your backend systems must be engineered to securely receive and execute signals from these external Consent Manager APIs. The trigger for all of this is processing. The Act defines this comprehensively as any operation involving personal data, from initial collection all the way to eventual destruction. It covers an algorithm analyzing user habits. It covers a customer support rep opening a service ticket. It covers your automated database backups running quietly at 3 a.m. Because every single touchpoint qualifies as processing, you cannot achieve compliance without first executing a comprehensive data mapping audit across your entire organization. When you process data, explicit consent is your primary mechanism. It must have 4 mandatory attributes: free, specific, informed, and unambiguous. This renders legacy design patterns illegal. You can no longer rely on passive banners, bundled terms and conditions, or pre-ticked checkboxes to capture user agreement. The law provides an alternative route called deemed consent. This allows you to process data without an explicit UI toggle, but only under highly specific conditions. Those conditions are strictly enumerated. They apply when a user enters into a contract to receive a service, during a verified medical emergency, or for direct employment administration. Deemed consent is a narrow exception, not a default fallback. Your interfaces must be engineered to capture granular, per-purpose consent that requires exactly the same amount of effort to withdraw as it did to give. As a platform scales, so does its regulatory burden. The government can designate specific companies as significant data fiduciaries based on their data volume, the sensitivity of their records, or risks to national sovereignty. Achieving this scale triggers strict obligations. An SDF must submit to independent audits and officially appoint a data protection officer who resides within India. Regardless of your size, the standard for a personal data breach is identical. The law defines it as any unauthorized processing that compromises data confidentiality, integrity, or availability. A hostile ransomware attack fits this definition, but so does an employee accidentally emailing a client list to the wrong address, or an engineer leaving a cloud storage bucket misconfigured. Both require immediate notification to the Data Protection Board. Under this framework, sloppy internal data hygiene carries the exact same regulatory weight and punitive threat as a sophisticated external cyber attack. To complete the architecture, Notice is the explicit document explaining your collection practices before a user signs up. Purpose limitation ensures you never use that collected data for secondary reasons without fresh consent. Data localization allows the government to restrict cross-border transfers. A child is strictly anyone under 18, and a grievance is a formal user complaint your officers are legally bound to resolve within a set timeframe. The Data Protection Board of India enforces all of this. Users can appoint a nominated individual to exercise their rights in emergencies, and interoperable sets the strict technical standard for systems communicating with consent managers. These terms form the technical and legal requirements for operating within India's data framework. Theory must now translate into engineering. If you run a technology business, there are 3 immediate operational steps to take. First, execute a strict data mapping audit. Catalog every single data point in your ecosystem and anchor it to a defensible legal purpose. Second, overhaul your consent architecture. Strip out the bundled terms and build granular consent flows ready to connect with external API managers. Third, audit your supply chain. Execute data processing agreements with all your vendors to legally lock down your third-party liability. Complying with the DPDP Act is an engineering problem disguised as a legal one. Use the Second Quadrant Consulting Solutions Readiness Assessment linked below to begin your structural overhaul today.